Under the Indian Penal Code, IPC, the law relating to insanity as a defense is primarily governed by Section 84, which states that nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Essentially, this means that if a person is of unsound mind at the time of committing a crime and cannot understand the nature of their actions or that they are doing something wrong, they cannot be held criminally liable. Key points about the insanity defense under IPC. Based on the Manhattan Rule, the Indian law on insanity largely follows the Manhattan Rule, which requires the accused to prove that due to their mental illness, they did not know the nature of the act or that it was wrong. Burden of proof. The burden of proving insanity lies with the accused. Unsoundness of mind. The term, unsoundness of mind, is used in the IPC instead of insanity, and refers to a severe mental disorder that significantly impairs one's ability to understand the nature of their actions. Two key elements. To successfully use the insanity defense, the accused must demonstrate both that they were of unsound mind at the time of the crime and that this unsoundness of mind prevented them from understanding the nature of their act or its wrongfulness. Important considerations. Medical evidence. In order to prove insanity, the accused usually needs to present medical evidence from a qualified psychiatrist to establish the nature and extent of their mental illness. Irresistible impulse, not recognized. The Indian legal system does not generally accept the irresistible impulse defense, meaning that simply having an uncontrollable urge to commit a crime due to mental illness is not enough to establish insanity. Court discretion. The court has the discretion to decide whether the accused was truly incapable of understanding their actions due to unsoundness of mind, based on the presented evidence. Case law examples. State of Kerala v. Ravi. This case held that the mere presence of an irresistible impulse is not enough to establish an insanity defense under Section 84. Ramadeen v. State of MP. The court emphasized that a sudden impulse to commit a crime does not automatically qualify as an insanity defense under Section 84.